So, hello everyone. I'm Gabrielle Marceau. I'm in the at the moment, and I'm delighted to be with you all and with the speakers for this closing panel, Roundtable on the rule of law and the role of lawyers in the 21st century. At the moment, I'm with, as I mentioned, an outstanding group of panelists. David Unterhalter, judge at the Supreme Court in South Africa, Court of Appeal, Professor Boisson Chazournes from Geneva, Stephen Vaughn, lawyer, practitioner from King Spalding, Professor Yang from China Tsinghua University, and Professor Weiler from New York University. They're all famous, they don't need introduction, but I'll say two additional words when they intervene. So my role is to moderate this closing panel for the SIEL conference this year. And some of you may remember that I used to be president of SIEL, and I was delighted to see that this organization continues to evolve with the new executive team composed of, again, people interested, if not passionate, by international economic law, including its president, Peter van den Bosch. And I have to add that I particularly like the fact that this year, all the sessions were recorded. So I was able to not only jump from one session to the other, as you may have done, but listen to things that were already passed. So allow me to say 2-3 words about the theme of this panel, and then we'll start with my friend David. The rule of law. So even though the rule of law has been promoted by thinkers for centuries, it was popularized, if you allow me, in the 19th century by Albert Veen Dicey, who found that everyone was equally subject to the law. However, today in the 21st century, the rule of law is at the heart of the United Nations. The rule of law for the UN is a principle of governance in which all states, entities, and persons are accountable and to laws that are equally enforced and independently adjudicated and which are consistent with human rights, norms, and standards. While the promotion of the rule of law faces widespread support on the national and international level, at least in public, there are divergent views, and it is often, or at least has become, a source of controversy. So today, the panelists will look at the concept and its application from different angles. They will all speak initially for 5-7 minutes, and then they'll speak again to allow each other to comment on each other and disagree. After that, we'll take questions from all of you participants. So David, as I mentioned, you're now a Supreme Court of Appeal in South Africa, but in the WTO, we all remember you because you were a member of the Appellate Body and president of the Appellate Body, and you've also been professor, arbitrator, etc. But let's jump to the heart of our discussion. Can you tell us how you understand the concept of the rule of law and its utility in international law, but in particular in international economic law? David.
Yes. Thank you so much for the invitation to be with you. It's lovely to be once more on a panel of this kind. I want to speak briefly about the evolution of the concept of the rule of law, and then talk a little bit about how it has utility, if it has utility, in the rather different settings in which it can be used when it is externalized in international law. So as Gabrielle has mentioned, famously, the idea or the concept of the rule of law was a key part of what Dicey had to say, but he was commenting on the notion of an English constitution and the essential component parts of what might make up that form of constitutionalism. Of course, the idea of the rule of law has then been elaborated upon for a very long time thereafter. But I think it's important to say of it that it carries with it an idea of legality that different commentators have understood in different ways at different times. And I think one of the central themes that I'd like to emphasize in my introductory remarks is simply that it is a concept that is often used in very different ways, and it becomes a badge of honor that is sought to be attached to different kinds of institutions and legal processes. But in fact, people mean often very different things by it and seek to attract legitimacy for their institutions when indeed they are really talking about rather different things. So let me explain what I mean by it. In its original concept, as propounded by Dicey and followed by Hayek and others, the idea had a very thin meaning. It was essentially a concept of rulemaking as some form of supremacy, particularly over governmental authority. It secondly contained a notion of equality before the law, which would mean that not only were all citizens equal before the law, but so too were the governmental authorities of a country. And lastly, that there would be a process of adjudication that would take place. Those were the three fundamental concepts of the rule of law. So conceived, it is a very formal notion of the rule of law. And although it does define important features of what can be taken to be the concept of law or the idea of legality, it is what might be called a thin theory of law. What has come, though, to represent the rule of law in wider and broader conceptions of this is to give it much greater content beyond these formal features. And so to build into it, as Gabrielle says, aspects of substantive rights and wider conceptions of human rights. And this is where both the use of labels and precisely what one means by the rule of law starts to shift ground, because for some, there would be an adoption of the rule of law in its thinnest possible conception to simply define certain of the operational or functional features of almost any more or less capable legal system. And for others, that simply doesn't suffice to have a meaningful content for the purposes of the rule of law. So I would just make the first observation that it's important to know what one means by it and how important it is that it has either a substantive content or is merely seeking to describe fairly formalized but not unimportant features of what the rule of law might mean. When we externalize the concept, and particularly under highly fragmented features of international law, and look at the different ways in which it might be of application in international economic law, one can take, for example, the WTO system. Under a highly formalized notion of the rule of law, one could say that it meets that criteria. It is a system of rules. Those rules bind member states. There is equal treatment of member states before the WTO, and there is a system of adjudication under which disputes are determined within the scheme of the system. But I think beneath that rather formalistic application, one can see an enormous number of differences that can arise. And I just want to emphasize one rather important feature, which has become such a well-known problem in respect of the WTO system. The system, as we all know, prided itself upon dispute resolution as an independent body that would give rise to the determination of disputes within the system. But it is the very independence of that system which has given rise to its gravest crisis. And so I want to say that one can see that even within a system defined under a very thin scheme of rule of law, the kinds of tensions that can be generated within an international application of the rule of law to, say, the WTO system, can give rise to enormous degrees of conflict where even under a thin theory of the rule of law, we might not be able to retain rigorous adherence to the rule of law. And so the crisis over the appellate body and the difficulties of how to appoint it and whether it is falling within its remit and properly adhering to its mandate are the very kinds of tensions around independent adjudication that mean that we can't always be confident that the rule of law can be safely applied, even in its most basic and formalized form. So with those initial observations, I'll stop there.
Thank you, David. I look forward to getting back to you with a question. How can we have the same rule of law applicable to states, entities, and persons? But we'll get back to you. And now, Professor Boisson Chazournes, Laurence, as I mentioned, professor in Geneva, University of Geneva. And like the other panelists, her CV was so long, I had to try to extract a few things. What impressed me, besides the fact that she's a member of the Institute of International Law, she's an expert on water, environment, and now a very arbitrator, including for the Hong Kong Arbitration Center, EXID, etc. Laurence, can you give us your sort of insight on this concept, but with a focus on international economic law? Does international economic law promote the rule of law, in your view? Thank you.
Thanks, Gabrielle. It's a pleasure to be with you all and I've been participating in listening to a lot of panels. So it's nice now to be sort of gathering the ideas that I've collected. So as Gabrielle said, I'm going to be looking at the rule of law from the perspective of public international law, okay? And one question, thinking about the rule of law in international economic relations, I just thought, are there principles which are common to all components of the international society? Because when we speak of the rule of law in international relations, we have a tendency to look at the principles of the UN Charter, and so we have a set of principles. But then, if we focus on international economic law, are there principles that could be constituting the core of the rule of law at the international level? So is there a rule of law with what I call a universal outreach? I'm going to be looking at that from the perspective of substantive rights and not procedural rights. I'm not going to be speaking about dispute settlement. David has mentioned that. I think it's a core issue of the rule of law, but I'm more going to be looking at the substantive norms of international law. So from the perspective of the universal ambit of international economic law, one would be tempted to look at customary international law and say that are there principles of international economic law with a universal outreach? And there, it's quite interesting because the candidates are seldom. What we have the principle of sovereignty over natural resources. It's a principle of customary international law. We might have also a principle dealing with certain limitation on state immunity in respect of economic transactions. That's it for international economic law. If we look at investment law, I think that one candidate is the minimum standard of treatment for foreigners. So that would be another norm of in customary international law. But if you look carefully at the standard of treatment for foreigners, and we have a lot of panelists who know a lot about this, we know that the content is rather unclear for the present time. And the case law has shown us that we don't really know what it means at the international level. So what we can conclude at the time being is that, in fact, customary international law, general international law play a marginal role for promoting the rule of law. And the main vehicles for promoting the rule of law at the international level are treaties. Okay. So that's one thing. So let's look at treaties and how do they promote the rule of law. So we're going to first focus on the WTO agreement. When I refer to the WTO agreement, I refer to the WTO constitutive instrument and to the other agreements concluded in the context of the Marrakesh negotiations. There we have a treaty with a quasi-universal outreach. We have about 170 states which are members currently of the WTO, and it's about 85% of the trade. So it's a very important organization. So what, if we look at the WTO, which are the principles that would constitute the rule of law? There we see that there is an inbuilt universality, okay? And it's an inbuilt universality around the principle of non-discrimination. So I think the principle of non-discrimination could be one of the core principles. And it has been, we've been able to promote the principle of non-discrimination within the WTO, thanks to the single undertaking, commitment, when states become members of the WTO, but also thanks to the specific commitments that states are negotiating on a bilateral level, and then they are multilateralized. But so we could say non-discrimination it was in its multiple facets, because there are different facets to non-discrimination. But then when we look more carefully even at the WTO, we see that non-discrimination is mitigated. First, we have the special and differential treatment for certain categories of states, and we can come back to this issue. We also have regionalism, which is there, Article 24 for the GATT, for example. And there, when you look at the practice of WTO, you see that you have a blossoming of free trade agreements, which are negotiated by the members of the WTO, and there are not really any strong WTO oversight over this free trade agreements. So is there, and it's a question, it's an open question, is there not a risk of fragmentation of the understanding of the rule of law in the context of trade with this blossoming of FTAs? And but then you could also think that we have the WTO and we have the FTAs, and maybe the FTAs could help strengthen the rule of law in the context of regions. And so we would have a differentiated and maybe improved situation of the rule of law in certain contexts, certain geographic contexts in the world. So that's one point for the WTO, but you see that it's a thin layer in terms of substantive law. Now, when we turn to investment law, there too, treaties play a very important role. Treaties play a very important role, but it's mostly bilateral treaties. It's bilateral treaties, and we have about 3,000 bilateral treaties dealing with investment. The bilateral treaties are key vehicles for promoting the rule of law. What is interesting in the field of investment is that multilateral codification has been largely unsuccessful. States have been reluctant to multilateral codification in the field of investment protection. So we have a bilateral approach, and you know that during all the conference, we've been speaking of different generations of investment treaties, and we've been focusing a lot on the new generation of investment treaties. And in the writings of colleagues, you can see that some say this is very good. It's a ground of experimentation for the rule of law. We're going to improve the rule of law with these new treaties. Maybe, but there too, I think there is a risk of fragmentation, which is quite strong. And the question that we could ask is that, is this bilateral treatification good for the rule of law? And that would be a first question. Now, even if we think we accept that we only have bilateral treaties, some say, but nonetheless, we have strong harmonization trends in the field of investment, and that has been discussed also during the conference. But even if we have strong harmonization trends around certain standards, I think it's quite difficult to ascertain at the universal level what is the content of the rule of law in investment law. And so questions come to mind, and they were discussed also during the conference, is that if states don't want to approach investment law through a multilateral lens, do we consider that they've delegated this task of harmonization to judges and arbitrators? Is it the role of the judges and the arbitrators to sort of strengthen the rule of law in the investment field? That's the first question. The second question that I have with respect to the rule of law in investment, in the investment area is, should the MFN, the most favored nation principle, play a role for multilateralizing the rule of law in the context of investment protection? Some say so, but it's an open question. And I think that we should distinguish the interplay of the MFN in the context of investment law than in the context of trade, where it has been negotiated and it's in the context of an institutional framework. So with these brief remarks, what I just want to say is that I think there is a lot of uncertainty at the universal level about the content of the rule of law between states, okay? And what I'd like to say also is that it seems to me that it's a choice of states. States have made the political choice, the economic choice, to master the field of economic relations through treaties and through certain formal treaties of different formats. Now, the last question is that we have this approach, it's the predominant approach, it's the treaty-based approach with a lot of risk of fragmentation. But the question that was posed by a lot of participants to the conference is that, is there room for another approach for promoting the international economic rule of law at the universal level? And there, the question that I think we should pose ourselves, and I think it's an important one, is that should other regulatory concepts such as environmental protection, social justice, sustainability, find their place within the rule of law? Are they not candidates to be integrated in the context of international economic law? And would we integrate, for example, the concept of sustainability? Would it be a vehicle for ensuring that we have a universal rule of law? So this is a question, an open question, and I hope that we can discuss all these issues. Thank you, Gabrielle.
Thank you very much, Laurence. A lot of questions. I'm sure the other panelists look forward to responding and discussing. The next speaker, Stephen Vaughn, is, as I mentioned, a practitioner in King and Spalding. He's done many things. When I met him, he was a terribly important person, not only a rich lawyer, he was general counsel of the office of USTR. Stephen, what are your views on the place and role of the rule of law in your daily trade practice, but also more generally?
Well, thank you very much for having me. And this is obviously an important topic, and I'm really honored to be here and to participate in this. I'd kind of like to talk about, all of us as practitioners try to work within the framework of what we call the rule of law. But one of the things that my experience, both as GC of USTR and also just as someone who's observed these discussions for over 20 years, I think that it's important to understand that each of us sort of brings our own history and our own traditions to this. For the Americans, when the United States began in the 1770s, we were part of a very, very successful international economic union that was based in London, but spread all around the world to North America, India, and many other continents. And the Americans felt that they were not being treated fairly inside that order. They didn't feel like the process worked for them, and they were prepared to commit violence in order to evade it and be out of it. The result of which most people have forgotten now, but at the time was a massive recession, which set back U.S. trade and U.S. economic development for several years. But in America, and for a very long time after that first war, the Americans went through several other wars, the War of 1812 and the Civil War, to try to figure out exactly what the rule of law was going to mean for us. And over all that time and difficulty, they came to a very specific set of compromises and understandings about what it means to act in accordance with the rule of law, and what it means in American politics and the way American school children are taught and the way American policymakers are trained to act is that items are binding on Americans if they're approved through our particular process. We have a constitution. That constitution governs pretty much everything that happens here. If something is unconstitutional, it cannot be binding on Americans, no matter what the process was. And on the other hand, if it's constitutional, then it is binding on Americans. That's what you're taught from the time you're a child in this country, and that's the way most Americans respect it and understand the rule of law. Trying to match this concept of the rule of law with other concepts that we hear in a lot of forums, like like this forum or at the WTO or in other contexts, it's a very great challenge for U.S. policymakers. Obviously, the WTO agreements itself were approved by Congress. They were debated in the U.S. They were supported by law, and they have been incorporated into our laws. So therefore, from an American perspective, there's no question that the WTO agreements, to the extent we changed our own laws in order to satisfy those agreements, that would constitute part of our rule of law. But I think what I see in other countries and in a lot of other institutions is, and there's been some talk of this already, is a much more ambitious understanding of what the rule of law could be. And that therefore it may be appropriate for these institutions like the WTO or like some of the investment type organizations that we've been hearing about, it may be appropriate for them to fill in gaps that were not resolved by the member states. And here, I think, is where we really come to a parting of the ways. I think it's very, very difficult for any American official, no matter how committed they are to the WTO, no matter how committed they are to international rule of law, no matter how much they want to work with other countries and how friendly they want to be with other countries, it's very, very difficult for them to tell the American people, we are bound by a decision, not something that was passed by Congress, not something that was written down in a treaty that we all agreed to, but we are bound by a decision from international arbitrators who have interpreted that provision in a way that the United States disagrees with. The Americans have traditionally responded very negatively to those sorts of things, and that explains a lot of, I think, what happened with the United Nations in the 70s and 80s. Is the U.S., they never left the United Nations, they never pulled out of the United Nations, we're still there, but they developed a much more distant attitude, I think, toward some of the actions that take place in that body. And I think you're seeing a similar development with respect to the WTO. It is very, very difficult, and I don't think you're ever going to see an elected U.S. official go to the people and say, I wanted to do this trade policy, but the people in Geneva told me that I couldn't do that trade policy. And so I think as long as that attitude exists, I think some of the more ambitious hopes and dreams of some of the other people in these institutions are liable to be disappointed. I don't see this as a bad thing, obviously. I think it's, as an American, and as someone brought up in our tradition, I am, I think, much warier of allowing unelected officials who are not directly responsible to the voters to make policy choices. I am not convinced that that's the best way to get law. I'm not convinced that's the best way to make policy. I understand that the process that we prefer through multilateral negotiations or bilateral negotiations that leads to outcomes that are supported by the sovereign governments of nation states. I understand that for many, many people hearing my voice, those processes are extremely slow and very frustrating, and a lot of you would like to go much faster. But our experience has been that we need to hear each other and we need to work together. And when we're not ready to move together, we need to respect one another. And so I'm hopeful that I don't think that the discussion that we've been having over the last few years about the WTO is necessarily going to weaken the rule of law or weaken the WTO. I think it is giving us a time to talk to each other, to see where we really are, to see, are there areas where we want to move forward? Are there other areas that should be revised? And are there areas where we have fundamental disagreements and we should simply respect each other and acknowledge those disagreements? So I'm optimistic about the general direction in which things are going. because I think the path that we were on, a few years ago was going too fast and was unsustainable. So those are my initial comments. Happy to talk about any of this further. And again, thank you very much for having me and allowing me to be on this panel.
Thank you, Stephen. I'll get back to your interesting comment, including on respect. But now, Professor Guohua, you're a famous professor at University Tsinghua. You were the first director of the first division on WTO, and now you are an arbitrator on the MPIA, that subgroup of countries created because the appellate body disappeared. So what are your views? I understand you want to talk about the rule of law in the context of the US-China relationship in particular. Please.
Thank you very much, Gabrielle. And David, it's so nice to see you here again. And Stephen, Laurence, Joseph, it's great to see you. I know, Gabrielle, this is the title is your favorite title. It reminds me of an excellent book edited by you a few years back, Law and the Lawyers in the History of the GATT and WTO, excellent book. So the title reminds me of the book. Thank you very much. What I wanted to share with you today is under this title, two cases from the US-China trade war, which is still going on. Started from 2018 to until now, between US and China. As far as you can recall, there are 3 rounds of the so-called US-China trade war in the past 4 years. The first round was about $50 billion tariffs against Chinese products, and also the 50 billion from China on US imports into China. So this is $50 billion and $50 billion for the first round. The second round is $200 billion by United States against Chinese products, versus $60 billion against the US products from China. So this is second round. The third round is the $300 billion against Chinese products by US, and $75 billion against US products by China. So this is the third round. Altogether, the 3 rounds products. So this is what I call the Great Trade War. This is in Chinese government's statement. This is the greatest trade war in economic history. So this is the background of the trade war we experienced in the past 4 years, and we are still experiencing. So in the trade war, or the Great Trade War, we see power and politics, right? We see power in the sense that there is a huge trade imbalance between US and China. This is not even-handed war between the two countries, because there is a $400 trade surplus between US and China, trade imbalance between US and China. So US could impose more tariffs on Chinese products, and China could not take the same retaliations. So this is a not even-handed war. So we see the power from the US side, and we also see the politics in the sense that the US-China relationship was destroyed almost in the past 4 years. There's no dialogue, there are only retaliations, no high-level communications between two countries. So this is really dangerous and risky. So this is the background, the US-China trade war. We see power and politics, but at the same time, we see also some legal perspectives in this US-China trade war. We see 2 cases, one in the WTO, and other is in the United States Court of International Trade, or CIT. So in the WTO, the case number is DS 543. This is the case by China against the United States on the tariff imposed by United States against China. So once again, this is a case by China against the United States, filed by China. And in 2020, September 15 last year, a WTO panel ruled against the United States, saying that the challenged measures or the tariffs imposed by the United States against Chinese products are prima facie inconsistent with Article 1 or MFN, most favored nation treatment, provision in the GATT, and also Article 2 or tariff binding obligation in the GATT. So in one word, the U.S. tariff was found by a WTO panel to be inconsistent with the WTO rules. So this is one case in the WTO or the international fora. Another case was a most recent case ruled by a Court of International Trade in the United States, or CIT. This is a case called in re Section 301 cases, series of cases. The court ruled just a few days ago, July 6th, a few days ago, that the court will temporarily refrain liquidation of any unliquidated entries of merchandise imported from China. This is a very specialized word, right? Which means that the people say that the tariffs would be suspended temporarily by the court order. So this is the effect of the court ruling just a few days ago, July the 6th, 2021. So
can you wrap up and bring all this under your comments on the rule of law and the role of lawyers?
Okay, thank you. So from these two cases and also from the U.S.-China trade war, we see skepticism about the power and politics. At the same time, we see optimism from the legal perspectives, which means that the law is working and lawyers are also working. Thank you very much. Come here.
Thank you very much. Now we'll finish the first round with Professor Weiler, Joseph Weiler, who's, as I mentioned, professor at New York University, who's been involved in several academic intellectual institutions in the field of European law, international law, WTO law. And I know that Professor Weiler wants to say a few words about the rule of law explicitly in the WTO system. So, Joseph, please.
Thank you. It's always such an endearing feature of academic conferences on the rule of law that the participants don't respect the rule of law of the conference. We were told 5 minutes each, and now we have had 4 speakers, and we're already on minute 38. One can do the math. Just tongue in cheek. So I want to highlight 3 areas where I think the WTO system compromises itself the rule of law. The first is the following. It's a fundamental principle of international law, equal to pacta sunt servanda, that when a state violates international law and causes harm to another state, it has to make reparations. The International Court of Justice has said that 1,000,000 times. It's written into the draft articles on state responsibility. And if we do not do that, we are basically allowing states to violate the law with impunity. The WTO system consecrated that, because under the WTO system, the obligation when you violate a WTO obligation is to cease and desist. But there's no obligation to pay reparations for damage already created. So I can imagine hypothetically sitting in some ministries and saying, let's impose a tax, and somebody says, but this tax is discriminatory, it violates Article 33(2). And the answer is, well, we'll do it. Eventually we'll be sued. We will wait between 12 and 16 months until the case is resolved, and then we will withdraw the tax, and that will be the end of the matter. So in effect, the WTO, and it gets worse, because although this is a little bit controversial, but I think the better view is that a state cannot, under the WTO system, claim damages for injuries created by violation of the WTO system, because you have to operate within the WTO system. So I think that's a very serious violation of the substantive dimension which David Unterhalter spoke of, the rule of law. It basically sanctions violation of the law with impunity. Number two, a principle of natural justice, which I think is fundamental to the rule of law, is audi autem partem, listen to the other party. The obligations of the WTO affect individuals. Usually, disputes among states commence by an individual operator complaining to their ministry, and then the ministry, if they want to, they bring a case against another case. They are a stakeholder, they are the principal party, and yet the WTO system works under the fiction that the government will represent adequately the interest of the parties which have been injured. And even though in a very good decision, the appellate body allowed amicus curiae briefs, an amicus curiae brief is not equal to an injured party who is a stakeholder of representing their view in a dispute. So I think that is also a problem for our understanding of the rule of law. And number three, it's a small matter, but in my view, it's a serious matter. The WTO, most panels overwhelmingly go to the appellate body. And the appellate body often finds that the panel did not exercise the right test in examining the case. I have in mind, there are many cases like this, but I have in mind the land case. And therefore, they overturn the decision of the panel. But there's no possibility for remand, because the fact that the panel made a mistake and did not apply the right test, so sometimes the appellate body can complete the analysis, etc., but not always. And quite, I don't want to say frequently, but not infrequently, it doesn't do that. And the rule of law and justice would demand, if a judge of first instance made a mistake in how to deal with the subject matter, which involves an assessment of facts, for example, etc., typically in our legal systems, the case will be not decided, okay, so you lose because they made a mistake. It will be remanded back to the court of first instance in order for it to retry it or re-examine the issues and reach a correct decision. And this possibility does not exist in the WTO system. And I think it wouldn't take much to allow some form of remand of a case to the panel when, in those cases where the critique of the appellate body, a correct critique, they applied the wrong test, etc. Thank you.
So the idea is that now we would go around the table last time before we ask participants for their question to have comments on each other. For instance, Professor Weiler was pretty, I would say, severe about aspects of the WTO, at least dispute settlement system, although the absence of damage can also be seen as a more, not only a procedural rule, but I would like you to comment on each other. Professor Guohua, you mentioned those disputes, but didn't mention much about your views of whether the rule of law is or is not respected, whether the existence of the possibility of initiating disputes help or doesn't help the rule of law. Stephen spoke very clearly about the difficulty for the American people to believe in rulings by arbitrators interpreting or applying the rule of law, but what about if it's written on a treaty? And Professor Boisson, Chazournes, your three questions were very informative. So I think we lost David Unterhalter. He's disappeared. So we'll go to Laurence immediately. You threw questions. You don't have to answer these questions. They're please comment on each other, and possibly I would be interested in hearing your views on what Stephen said, for instance, or anything else that you find useful.
Thanks, Gabrielle. So it's what is interesting with the rule of law is that we each have our own understanding of what it should be. So it's a nice concept for being able to speak together. But it's quite interesting for me to see that the procedural issue aspect is key. For example, I think for Joseph, and we can come back to that, the good functioning of dispute settlement seems to be an important also matter for Joe and for David. And I think rightly so, because it ensures respect of the rule of law. Myself, I was a bit concerned with what is the content of the rule of law as such. And there I go to the WTO. And Stephen, I was taken by the fact that there is a need to respect each other. But we international lawyers, when we negotiate treaties and discuss and exchange in different arenas and fora, we think that we respect each other. But at the end, I think the respect for each other is the outcome is a compromise view among each other so that we can have a good functioning of the world order. So I would be interested in understanding a bit more what was missing with the respect of each other in the context of the WTO. And then, Yang, when you spoke about the disputes, in fact, you referred to the trade war which is going on between the two major powers of the world. The European Union is also a major power, but I think that the US and China are key trade actors. And you referred to two disputes that have taken place within the WTO, but there is so much which is going outside of the WTO. And one thing I was thinking when listening to you is I was thinking at the African proverb, which is a Swahili proverb, which says that when elephants fight, it is the grass that suffers. And with that, what I want to say is that in this context, the two major powers are, I think, shaking the foundations of the system as we've built it in the 90s and before in the 40s. And I'd like to have your own understanding of this within the WTO and outside of the WTO, and how, in fact, and maybe it's also a question for Stephen, how all this could be brought back within the WTO so that there are agreements which are found and that the others, because there are many of the others, are not suffering from this issue. Thanks.
Stephen, do you want to speak now or after Yang, as you like? I think.
Speak now. Yeah. Yeah. So I just have a few comments to make. With regard to the issue of respect for each other and respect for different systems, I would argue that the WTO, and especially the WTO dispute settlement process, has been far too willing to fill in gaps. I think a lot of questions were left open in 1993 and 1994. Those decisions, those negotiations, as you know, as everyone knows, were very difficult and were very fraught. There were a lot of issues that were resolved. There were a lot of issues that were not resolved. I think in a situation where issues were not resolved, that means that the parties are free to act in accordance as they choose. They have not bound themselves. They have not made a commitment to anything new, and they should be not forced to do something that they didn't agree to. So I think we need to, I look at the WTO as more of a contract. I think a lot of people outside the United States tend to look at it as more of a process. And you have signed on to the process and you take whatever comes out of the process. That is not how it's viewed over here. We tend to look at it as a contract. We agreed to this, and we did not agree to anything that's not this. So if you wanted to completely rewrite Title VII and change our anti-dumping and countervailing duty laws, which I think was something that obviously a lot of people inside the WTO system wanted to do, then you needed to get us to agree to it and not try to use the dispute settlement process to get outcomes that you weren't able to get through negotiations. So that would be sort of my initial answer on that. I think with respect to this whole issue of a trade war between the U.S. and China, I think, I mean, we can use whatever terms we want to use. I mean, certainly on the U.S. economy, our economy did very, very well in 2018, did very, very well in 2019, was obviously affected by COVID, but is now doing very, very well again. So I think to try to compare this to sort of huge trade disputes of the past that, may have contributed to economic downturns and stuff, I think would be really misleading. But I would suggest that if you really look at what happened between the United States and China in the period from 2017 to 2020, I think we made a lot of progress. And I think we made that progress not because we went to court and not because we sued each other and not because we turned international arbitrators, but because the high-ranking officials, the political leaders on both sides and in both countries sat down and had very serious and very real substantive conversations that went far beyond anything that we had been talking about before. After years of talking past each other, we were finally in the same room having real meaningful conversations, and that resulted in the so-called Phase 1 deal in early 2020. Again, that got overshadowed to some extent by COVID, but I think that was a great outcome and a great victory for the two countries, and would have worked out very, very well. And so my final comment would be, I do not think it would help the U.S.-China situation to have both parties refer everything to the WTO. I think the relationship between the U.S. and China is a unique relationship. It's one in which both countries have a great deal at stake. And I think we will find that it's more productive if we talk to each other, like we were doing in the period from 18 to 20, as opposed to hoping that, some sort of international body will come up with rules that are amenable to both sides. I think you're going to find that strong political leaders are not going to be that affected by outside arbitrators. They know how to wield power. That's what they do all the time. They know how to negotiate. That's what they do all the time. They're very good at it, and I think we should let the political systems work. In a lot more system, in a situation, particularly in something as delicate as U.S.-China. I think letting the political people talk to each other and letting them work it out is going to be a lot more effective than getting professionals and technocrats like me to lay down, rules that won't necessarily reflect everything that the political leaders have to take into account.
Thank you, Stephen. I'm from the comments received so far from the speakers, I see that there's some sort of strong association between the rule of law and dispute settlement. And that's why I was interested by Laurence's comments more on the substance and raising issue, for instance, is MFN or non-discrimination one of those substantive rule? So, Stephen, are you saying that the rule of law can be respected outside WTO dispute settlement system, or are you saying that peace on the planet would do better between at least China, US, and big players if we were not thinking in terms of the rule of law, or if there was no dispute settlement system? I go back to you and I see there was a question. With your conception, do you think that there can be binding dispute settlement, or would this be against the rule of law? I'm trying to understand better your relationship between the rule of law and what you believe is healthier in terms of relationship, not to rely too much on dispute settlement at the international level. Thank you.
I think these things should be judged by their outcomes. From the late 40s until the early 90s, which I think almost everyone here regards as one of the golden ages of globalization, we did not have binding dispute settlement. And the result was 40 years of economic integration, tearing down barriers, working together, strong economic growth, and eventually, basically acceptance of a lot of these principles that we're talking about worldwide. In the late 40s, when the GATT was first started, people didn't necessarily share these views, right? I mean, those were policymakers who were coming out of a very different world. By the early 90s, a lot of the values that people here care about had become much, much more popular. That didn't happen because of binding dispute settlement, because they didn't have binding dispute settlement. So I think the notion that we need binding dispute settlement in order to promote the type of policies and outcomes that we want is simply incorrect. In fact, I think that the greater threat to the system is that if you have binding dispute settlement, the arbitrators will move too quickly, will get ahead of the politicians, and will create the so-called democracy deficit that we've heard about in other contexts, where policymakers are being forced into situations that they simply cannot sustain. There has to be enough flexibility in the system to allow for the political leaders to justify their actions to their own constituents. Arbitration is not good for that. Look, I am a litigator. I know what it's like to litigate cases. You try to win. You try to beat the other person. You try to, win every issue and get as much as you can for your client. That may be good for me as a litigator. It may lead to very sort of clean lines and clear doctrines, but it's terrible politics. It puts people in situations that are politically unsustainable. What if it turns out, for example, that two countries can get along great with each other as long as there is a recognition that this one industry in this country is going to get special treatment and that one industry in the other country is going to get special treatment? That's a pretty easy deal to work out at a political level. It's almost impossible to do that through binding dispute settlement. So I think, I'm not saying that, look, there may very well be a situation where you have two political leaders and they're in a negotiation and they get into a back and forth over who has the better of the argument in terms of the old treaties that they've all agreed to. And there may be very well a case where referring that question to arbitrators and getting an independent answer will help the political people come to a deal. But that is it. That's the only real reason that's the only way dispute settlement really helps, because ultimately we're talking about 164 some odd nations. They're not going to do what they're told just because somebody told them to do it. If you want them to get deals, encourage them to make deals. Our role as technical experts should be, okay, if you really want to know what we think the treaty means, this is what we think it means. But ultimately, it's up to you, the political people, to decide, what you're going to do.
Thank you. I'll go back to you afterwards because I'd like to understand or see your perspective as to why the U.S. is the first initiator of dispute complaints in the WTO. But I don't know whether Yang or Joseph wants to go next. Yang, your entire presentation was about those disputes, about the trade war. So what's the link with the rule of law and the trade war? Or is it that the trade war has killed the rule of law? Or what's the link, please?
For the link, as I said, there are the skepticisms of the politics and power in the trade war, but we still also see the optimism in a legal perspective for the two cases. We won the case, and one of the some U.S. companies won a case in the U.S. Court of International Trade. So before I come back to Laurence's question, I guess to me and also to Stephen, on the what China and the United States, two major trading partners, could do to bring back to the rule of law to the WTO, I would quote a saying by United States Secretary of State Blinken, the statement that the United Nations Security Council opened debate on multilateralism back to May 7th this year. But Secretary Blinken said that all members should meet their commitments, including the World Trade Organization. And he continued to say that I know that some of our actions in recent years have undermined the rule-based order and led others to question whether we are still committed to it. Rather than taking our word for it, we ask the world to judge our commitment by our actions. When I read and heard this statement at the United Nations open debate in front of the whole world, I was thinking of the case, right? China won against the United States. That was DS 543, as I said just now. So what should the United States do with this case? So come back to the question very simply. to the question from Laurence on China as an idea on how to bring back the rule of law to the WTO, I think it's easy. It is very easy for me and for many Chinese. You know, China joined the WTO 20 years ago. This is the 20th anniversary. And and China also was very actively involved in the dispute settlement cases. We have many cases. And so to many Chinese, including me, so WTO has a set of rules and China need to abide by the rules, number one. Number two, WTO has a dispute settlement system. China also need to implement the rulings. So although the China does not not necessarily agree to all the rulings by the WTO appellate body panel, but China tried to implement all the rulings, including the rulings filed by the United States against China on the so-called rare earth. And at the time, I met with the current USTR, Catherine Tai, in a WTO headquarters in the hearings in the rare earth. So we lost the case. We implemented the rulings, although China does not necessarily agree to all of the rulings. So in one word for China, so we have a set of rules in the WTO. We have dispute settlement, just abide by the rules and follow the rulings, no matter whether we agree on the rulings or not. So this is so simple for China. Thank you.
Thank you. Professor Weiler, Joseph, you spoke mainly pacta sunt servanda, the problem of no damage, remand, very focused on dispute settlement, and you're welcome to add or comment. But my question to you is more with respect to Laurence's point, that the rule of law would include necessarily substantive norms, such as non-discrimination. So I'd be interested in hearing your comments on whatever you like to add, but also on this issue. Are you of the view that dispute settlement is inherent to the rule of law? Probably not limited to this. Thank you.
I'm sure it's my fault. But the first and most important point I made was not procedural or dispute settlement. It was the substantive, fundamental principle of international law that when a state creates an injury, it has to make reparation. And that is a substantive point. It's not a procedural point, and it has nothing to do with dispute settlement. It exists also in frameworks where there's no form of dispute settlement. And the reason I mentioned it, number one, because I think it's so important, because if we don't have that principle, we're basically saying you can violate the law with impunity. This has nothing to do with dispute settlement or procedure. And because this is one area where the WTO, which on the whole enhanced the rule of international law, this is one fundamental point where it regressed and it compromised something that was considered an acquis of public international law. You cause damage, you have to make reparation. So I just wanted to clarify that point. I want to make a comment on what Stephen said. I'm not so sure that the American people, speaking as a fellow American, I'm not so sure that the American people are at all interested in the WTO. I think it's the classe politique, it's Congress that is up in arms when an adverse decision comes, although the United States has won most of its cases. I remember giving testimony to Congress on the gambling dispute, where it was any good faith person will say, if you allow internet gambling to your private operators, to your American operators, you are probably discriminating when you do not allow it to outsiders. And I said to Congress in giving evidence, look, it's in our interest, because if we violate this rule, what will we do when, say, China does the same thing? And one of the senators just looked at me and said, oh, don't worry, we will deal with it. So I think if there is aggravation, it comes from la classe politique. Now, in this respect, I agree with the basic sentiment of Stephen Vaughn. In an article I wrote many years ago, The Rule of Law and the Rule of Lawyers, the purpose is dispute settlement. And it's not clear that going to law is always the best way to resolve a dispute. for the reasons that Stephen gave, you know, when the courts or the panels get beyond themselves and invent law, but also because the nature of judicial proceedings is that you have a 4-0 decision. And the nature of dispute settlement and negotiation is that you have a 3-2 compromise. Nobody feels that they really lost. But there's a dark side to that, Stephen, which you will agree with me, that when the United States goes into negotiation, they have huge leverage. And if they're negotiating with a smaller power, it's really unequal. And judicial dispute settlement helps to ensure equality of arms. You don't get your arm twisted by a major power. So it's a little footnote. On the whole, I agree with your sentiment. And if we want to talk, Gabrielle, about the role of lawyers, there was such enthusiasm for the new dispute settlement provisions of the WTO in 1995. You could just see in the Ministry of Trade, let's sue them, let's sue them. Lawyers want to go to court and lawyers want to win cases. And they lost that prior instinct, let's resolve the dispute. So in that respect, I'm very much in line with Stephen Vaughn, and many, many cases which got to the WTO panels and appellate body could have been resolved without all the acrimony, the miles, the fees, by negotiation. And there, the lawyers have played a negative role because it's their instinct. We want to go to court, we want to win cases, we want to have another feather in our cap. And that is sometimes inimical to dispute settlement. Finally, to answer your question, yes, I do think that dispute settlement before, this is in all law, domestic law, international law, all fora. When there's a dispute, it should be decided by an independent body. And when we don't have a functioning judiciary, an independent judiciary, an unbiased judiciary, a political judiciary, these are the indications when the rule of law is compromised, and it's might rather than right that wins. So I absolutely believe that coherent dispute settlement with integrity is an essential feature of the rule of law.
Thank you. And you're right, Joseph. I was wrong if I did sort of limit your statement on compensation and damage to a procedural issue. I'd like to hear you further later about how to put this in practice when a government sues another one for a subsidy provided, how to make sure that the government that loses will really collect the money back from the companies. There are all sorts of practical problems, but you're very right.
I have some
Okay,
idea.
good. I'd like to hear you. And you're very right that this sort of a passion for lawyers, when I started many years ago in the legal affairs, I think I was the 3rd or the 4th lawyer. And at some point 2 years ago, we went up to 80 staff assisting dispute. So you can imagine it is true that people forgot how to settle. And interestingly, if you look at the settlement in the hormones dispute between EU and US or GMO, you look at this, you sort of wonder how come they were not able to make this deal sort of, 15 years earlier. So there are a few questions in the box. I don't know whether many are dealing with dispute settlement, independence. I don't know whether, before I read out some of those questions, because the idea was I was going to throw out questions and ask you again to intervene, whether one of you really needs to say something. No, you're all sort of, yes, Laurence?
Yeah.
Yes.
Maybe just a question for those who know well the DSU. The DSU is not just about establishing panels and resorting to the appellate body when it was still alive. The DSU also provides for negotiations, for mediation, for good offices of the Director General and so on. And the question that I have for those who know better the WTO than I do, that why haven't states been interested with this diplomatic means which were at the disposal, and they in fact agreed to resort to them when they negotiated the DSU. So why not looking at negotiations within the WTO without going before a panel or the appellate body? That's the first question. And now, taken by what Joseph Weiler said about the violation of the Pacta sunt servanda principle, I'd like to take him to the European Union and to the functioning of the European Court of Justice. So is there at the European level a violation of the Pacta sunt servanda principle? And the floor is yours.
It's quite interesting, those questions. Allow me to add maybe one or two, and then Joseph, and on the way, then Jan and the others can respond. In particular on the why there was no, and allow me to respond a little bit, Laurence, why use of mediation, good offices, although there are a couple of good ones like in Banana, but I think that the idea, and maybe this was caused by the appellate body to some extent, the idea was the countries that believe that the other side is violating was always convinced that they would get more through dispute settlement than through negotiation, which maybe was right or wrong. But I'd like also you to speak about the independence of, as Joseph mentioned, and it's been put in the questions, the importance of independence of judge domestically, and whether or not there is sufficient control in international adjudication. You know that the Americans, for instance, were of the view, and they wouldn't put it this way, and I'm not putting it properly if I say unfair, but they were of the view that some of the reports, adjudications were not fair, were not respecting the treaty, and this could have been caused by the background and education of those who decided. There are also, I'd like to hear you more about compensatory remedies. Again, as I mentioned to Joseph, how that we do have anti-dumping, as you know, in CVD, but that's different, and that's national, and that's adjudicated. How to implement remedies in international law between states which act often under diplomatic protection for protecting businesses. So, and there's a series, you've seen them, Stephen, in the question, a series of questions to you about believing or not in sort of international adjudication. And one to Joseph here, do you think there's a good time to make high pressure to apply in substantive extent non-adjudicatory tools to resolve conflicts? So these tools, you all know, exist. Good offices, mediation, conciliation, it's all there. I've helped DDGs speak to the membership, encourage them to use them, facilitate. How come it's not done, do you think? So I suggest, since Laurence just spoke, that we start with Stephen, and then Joseph, and then Yang, to change a bit the order. And then Laurence, of course, after.
So obviously, you know, one of the things that I thought about a lot as General Counsel of USTR is, if we have a dispute with another country, what's the best way to go forward? And can we use these type of you know, good offices and mediations and things like that? Part of what happens, I think, when lawyers look at the WTO dispute settlement process is that the plaintiffs almost always win. They win overwhelmingly. I mean, by a percentage that's just really sort of incredible, actually. The U.S. wins most of the cases it brings. The U.S. loses almost every case in which it is sued. Under these circumstances, I think you're going to find that lawyers who think they're going to win aren't really that interested in negotiating. They don't really see much of a reason to do it. They don't have to do it. They're going to just win. And so they're not interested in your mediations or your good offices. The other reason it's not used is that if you're in a situation where you have a dispute and you're the United States, for example, you don't really have a lot of leverage over people unless you're prepared to either bring a dispute and pursue the dispute and try to win, or unless you're prepared to use some of the other techniques that we use, you know, like Section 301 and some of these other type of things that we turn to. calling up sovereign countries on the phone and saying, hey, you know, we really think you're doing something that's wrong here. Will you please agree to negotiate with us and change? That's just not going to be very effective. You need to have some reason as to why they would change. And they're not likely to change unless you have some sort of a leverage. If you're not prepared to get leverage over them in other ways, disputes are really your only option. And once you've brought a dispute, you may as well just carry the dispute through to victory and win. So I want to just make one final comment, which is I couldn't agree more strongly with what Joseph has been saying about, you know, how the lawyers have hijacked a lot of this process and turned it into something that it was really not meant to be. We are, once you bring us into the process, we are going to try to win. That is our job. That is not only that's our ethical responsibility to represent our clients as aggressively and as effectively as we can do. We're not here to get 3-2 outcomes. We're here to get 4-0 outcomes. And that's what we're always going to try to do. So I agree very, very strongly that this process has to be kept within strict bounds, and that the politicians and the political leaders, who I think are much better at negotiating than we are, much more sophisticated in terms of all the relations between states, much better at balancing, you know, what's good for foreign policy versus what's good for the domestic policy. They're the ones who should really be in the room doing these negotiations. We should only get involved in situations where resolving certain technical understandings of the texts will be helpful to fulfill those larger negotiations.
So, Stephen, allow me to jump in. Deborah Steger just mentioned that at the beginning of the WTO, the US initiated a lot of old disputes. Myself, I did a lot in banana. And if we set aside trade remedies, US wins all the time against China in agriculture.
Not when it's on the defense.
Sorry, what?
We don't win when we're on the defense.
Yeah,
even when it's not trade remedies, we don't win.
Right, you're right. But when you initiate like banana, so what has changed? Because the rumors or the corridors report that it's the US who wanted the strong dispute settlement system. Are you saying, do I understand you, that it's the lawyers who hijacked the process and it was not supposed to turn this way before Joseph intervened?
I certainly think the United States had a fundamental misunderstanding and made a grave error in terms of how the process was going to actually work. I think they were naive and misguided in terms of what they thought was going to actually happen. You are correct that they had had a lot of disputes with the EU and Japan that had been out there for a long time. As I mentioned earlier, we don't have a lot of leverage over the EU. We don't have a lot of leverage over Japan. It's very hard for us to resolve these disputes. I'm sure that U.S. policymakers at the time hoped that the dispute settlement process would give them more leverage. It did not. The Fujifilm case was a disaster for the U.S. Cases like bananas and GMO, all they really did was invite counter cases from the EU on foreign sales corporations and other issues. The U.S. got hammered in those cases and ended up with less leverage than it had before. So you're right. They did try that. It was a good faith effort. They thought it was going to work. I'm not criticizing them for trying. I understand, why they thought what they thought. And I want to be very, very clear. I'm not criticizing any of my predecessors at USTR. I know they were doing the best they could. And they had very, very high hopes, and it didn't work. But because they made those mistakes, and again, I'm not saying they were mistaken at the time, that maybe this was something that had to be tried. Now it's time to move on. Now it's time to realize it's not going to work. It's not ever going to work. The United States is never going to be able to show up on the doorstep in Brussels with a court order saying you have to do what we're telling you. That's never, ever going to happen. And American policymakers need to let it go and need to rely much more on negotiating and diplomacy, which is historically something that Americans are actually pretty good at.
Thank you. Joseph, do you mind stepping in? There's so many things I'm sure you can comment on, please.
So my first comment is going to be tongue-in-cheek. I'm so glad that the Americans were naive, because if they were not naive, we would not have had the dispute settlement system, and we are better off with it, despite all its flaws, than without it. And The second thing, when you say it doesn't work, it does work. It just doesn't work in a way the Americans would want it to work, which is to win every case. I'm just teasing, I said tongue in cheek. I want to go back to the question of reparations. The way you asked me, Gabrielle, it seemed to suggest, I'm not sure, I don't think that was your intention, but it seemed to suggest this would be a major innovation. It isn't. It's the standard practice of international law in all areas, that when a state violates the law, another state complains, they measure in various ways the damage caused, and reparations are made. It happens all the time, hundreds of times, in cases of expropriation, in cases of mistreatment of aliens. It's the normal standard practice of international law. So this would not have been an innovation. The innovation was to take it away. And the WTO would be able to do it much better than the primitive system of normal international law. Because think of the sophisticated procedures we have in the WTO when we have to assess the extent of countermeasures when countermeasures are allowed. Also there, we assess the damage, the countermeasures must correspond to the damage. Now, it's a different calculus, but the fact that there is a mechanism objectively to do it would mean that if one accepted the principle, if you've caused damage, you have to make reparation, and it will be from state to state, and then the receiving state will decide, as is normal in international law, how to distribute between private parties which were injured. I think the WTO would have a much better chance of doing it in a controlled, sophisticated, transparent way, arguing before a panel on the measurement of, just as we do it when we look at countermeasures and we have to assess what is the extent of the countermeasures which will be allowed. So no innovation at all, just restoring the WTO to the normal practice of international law.
But Joseph, allow me to intervene here. Why is it that it was not under the GATT? It was never in the sort of GATT WTO, never even considered, immediately set aside. In your instinct and judgment, why is it that it wasn't done? That is, a mechanism providing for damage, because we don't have damage. You're right, we only have retaliation, sanctions. So, but it can be very often similar in terms of level.
I actually tried to research it unsuccessfully, so I can only give you my speculation if you want. So it's interesting because the system of investment and the system of trade developed more or less side by side in the 50s and 60s, etc. And in the investment world, it was taken for granted. If damage is caused, reparations have to be made. Even before the, under the multiple bilateral investment treaties, I think the negotiators of the GATT didn't quite internalize or assess that violations of the GATT actually caused injury to private operators. In the same way that under normal public international law, mistreatment of nationals or expropriation. It wasn't. The world of expropriation of private parties was something on the investment agenda, not on the trade agenda. It was thought that trade is between states, and they didn't see the impact of creating injury to economic operators within a country. I really believe that that was the mindset of the negotiator, but it's speculation. I don't have hard evidence. And if you don't have that type of injury, which you do have with investment transparently, then they thought in the same spirit of Stephen and I, that's something that states should negotiate among themselves rather than go to that. But I really believe that that was the idea. This is a dispute between states. It doesn't create the kind of injury that we see in investment. And that's why in parallel, investment went in one direction and trade went in another. Speculation.
Yeah, I mean, I think that you also have to kind of think through what would actually happen sort of in the real world. Like, how would this actually work? So let's say the United States loses one of its many Title VII cases, and the United States is levied a penalty. And then at that point, Congress is supposed to appropriate money to go to private countries, parties in other countries where the U.S. government has found that those countries are engaging in unfair trade that has caused material injury to domestic producers. And that's a heavy lift politically.
It's not so much. This is how
it is. I think it's going to be very
understand.
difficult. In other words, so you have a case, and steel workers have lost jobs, steel mills have been shut down, people have been injured, the ITC finds injury, the U.S. government finds injury, the U.S. government imposes tariffs, WTO says, no, that's all a violation, you shouldn't have done any of that. You now owe the foreign steel makers a certain amount of money. And then Congress is just going to appropriate that money?
It doesn't. Let me try and answer. Because for decades, for centuries, when American interests were injured, private interests were injured in other countries, like expropriation, etc., the United States would go and say, you've injured our private individuals under public international law, that's an injury to the state. You have to pay compensation. The compensation goes to the United States. It doesn't go to the injured party. And then the United States does with the money what they want. All the Cuba business, etc., it was all premised on that. So it's the same principle. That's what happens regularly. It doesn't come under USTR, but it comes under investment even before exceed and etc. So it's a very standard procedure. You injured my individuals. I bring the case because under international law, the individual doesn't bring the case. You pay me compensation. Then I do with the money what I want. Some governments distribute to the injured parties. Other governments pocket it. There are known cases of that. But yes, that's what the United States expects from its partners in all other areas.
But not in this area, right? And but not in this area. And I think the reason not in this area is because the political leaders in the U.S., I can't even imagine asking the EU to pay us for beef hormones. But
I want to ask you a non-tongue-in-cheek question, just to explain why this is not as radical. Because now when there's a violation, countermeasures, sanctions are allowed. There's an assessment of the damage. And we have the ludicrous solution, instead of the country which caused the damage coughing up and paying compensation, the company that suffered the damage will impose trade sanctions to the amount of the damages, and the system suffers because now instead of more trade, we have less trade.
And I think the answer to that is that the US policymakers and the EU policymakers and all the people who agreed to these treaties, they thought it was very, very likely that you could have a ruling that would go against you and would not be regarded as legitimate. I mean, I think the idea that the Congress is going to appropriate money just because we lose a case at the WTO, I can't imagine proposing that to members of Congress. I think they would absolutely refuse. They would say, we don't think we violated the law. We don't think we did anything wrong. We're not appropriating the money. We refuse. So, and I think that's why it happened. The idea that we could take us out of the equation. So we go to Europe and we say, okay, Europe, you owe us all this money because of the beef hormones case, which we won 20 years ago and where you've never come into compliance. There's not a chance in the world that France is going to write us a check for that.
That's
never going to happen.
I don't think that's the case.
Go ahead.
Let me answer in two ways. The first is that there's zillions of cases where countries coughed up money and paid them to the United States. Lots and lots of cases, in cases of expropriation, which this has happened. So there the Congress was the recipient of the compensation paid by a foreign country. So as I say, it's not so radical. What is sauce for the goose is sauce for the gander. But I have a more deeper point. The basic argument you're saying is that Congress would never accept it. And you might be right. But does that mean that the system is a good system because the Americans don't like it?
Well, I think this goes to sort of what we've been talking about. To me, the question about the rule of law is who has the legitimate right to tell Americans what they're supposed to do? Who has the legitimate ability to take our tax money and spend it as they see fit? I'm willing to concede that our Congress, elected pursuant to our Constitution, has the legitimacy to order us to do certain things and to pass laws that we have to comply with, assuming that those laws are consistent with our Constitution. I don't think that international arbitrators have that type of power over America, nor should they. As we all know, the Americans would never have approved the dispute settlement process unless the Americans had the right not to comply. because at the end of the day, this is our country and we have to make our own decisions about what we're going to do. So I can certainly understand that some people don't think there should be sovereign nations, and some people don't think there should be independent nations, and they'd rather have you rule by international bureaucracies. But that's not been the American system, and I don't think it should be the American system.
So that's on the second question. That's where I beg your pardon. Sorry, Gabrielle.
No, that's all right. I was just encouraging you to maybe go to the next question, and I'll go to Yang because I would really like your inputs and views as to why is it that governments do not use the soft non-adjudication means available to them, and each time they were used, they were very successful. Why is this? But Joseph, go ahead with your second point.
I just want to say, I will answer that question in a minute, but to Stephen, I agree that the Americans don't like it. That they shouldn't is a different question, because when America goes to court, they expect other countries to comply. When they go to the ICJ in The Hague, when they go to any international forum, they go, they win, they expect the other country to comply. So I think they should also comply on the should. Understanding American politics and American exceptionalism, America never liked to be told by some international tribunal what to do, not only in trade, also on the death penalty, on a whole range of issues. So it's part of American exceptionalism. So whether it would happen or not, I agree with you. Whether on your should, that I may beg to differ. Why don't they use softer? Look at the statistics. The statistics that are interesting here are, it's not who brings the cases, against whom the cases are brought. And there you see that overwhelmingly the cases are brought against the European Union and the United States. They are the most frequently find themselves in the dock. Why is that so? For two reasons. One is because they are the biggest importing country. So when they have a rule that violates the WTO, it affects more economic operators. The United States consumes about 2/3 of industrial products produced in the world. So it hurts more when they violate. But there's a second reason, because a lot of small countries don't think they have a chance in hell if they negotiate with the European Union or the United States. The inequality of arms is so great that they rather go to court and hope to win and get a decision in their favor.
Joseph, we'll go back to this, and Stephen, you will be able to further comment. And interestingly, one question linked to this that just came from Holger was, do you think that if the US ever loses an investment case, the US would refuse to pay and terminate all its investment agreements? But no answer for now. You can do this. I'd like to hear you, Yang, on these two initial questions. First, the rule of law. What is the substance of the rule of law, substantive norm for you? You talked about disputes, or is dispute settlement the main sort of component? And the other one is, as a member of the MPIA, you certainly believe in adjudication, in appeals, but as a Chinese, you also, I'm sure, believe in negotiations and trying to reconcile, especially big groups. Why is it in the WTO that governments do not make use of the existing provisions highlighted by Laurence, which we used? I worked a lot, I assisted Lamy a lot on the banana sort of good offices, and it was a success. Why is it, in your view?
Thank you, Gabrielle. For a second question, I think for China, it's easy. We solve a lot of problems, a lot of disputes with, for example, United States by bilateral dialogues. We had regular high-level dialogues. We solve a lot of disputes. Number one. Number two is that also, if you look at the cases in the WTO related to China, about 50 cases. So almost half of the cases were solved by the consultations. So China was always willing to solve the cases, the disputes, by consultations. In my mind, consultations is part of the negotiations, right? Although it's in the WTO already. So the reason to come back to your question, the reason why not using the other mediation good offices, because China has other more effective ways, dialogues, negotiations, consultations. For your first question on the rule of law, as I said at the very beginning, at least in the context of the WTO for China, so abide by the rules, abide by the commitments you made in the WTO. For example, China joined the WTO 20 years ago. China made a huge amount of commitments, abide by the commitments. Secondly, abide by follow the rules, the rulings by the dispute settlement. So abide by the rules and the rulings are the basic understanding, the basic understandings for the rule of law, to me. Thank you.
So you do believe, based on the dialogue process with the US, that this is a good way, maybe even a better way than adjudication. Laurence, do you want to come in here, please?
I'd like to make a few points because so I've heard about the remedy, reparations, and so on. It's true that in the investment field it's reparation, quasi-automatic when there is jurisdiction and there is a violation. But it's quite interesting that in the literature there is discussion about the fact that reparation should maybe not be the only remedy, and maybe we should also think about withdrawal of legislation and so on. So why not diversity? And that's the first reaction that I have. The other question, and it's for you all, is that WTO, I look at it from a collective interest perspective, because it's not just a settlement of a dispute between two partners. There are third parties, and Article 10 is very important in the DSU. There are a lot of parties who have an interest in the settlement of the dispute. So it seems to me that when we speak of the withdrawal of legislation or the modification of legislation, it's going to be to the benefit of the claimant. It is also going to be to the benefit of the other actors, the other members of the WTO. So would that be one reason for the stress, the importance given to this remedy? So that's one thing. Now the negotiations, and this is for Yang, it's China and the US, they like negotiations, but they don't like it within the WTO. So why? Okay, and one question that I have is that would it be within the the WTO? Then it would have to be made public, and the MFN would find application. So it would be to the benefit of the other members. So is it not a reason to have it outside? That's a question. But for me, all what I hear is that there is a risk of fragilizing the WTO very much with these negotiations outside. And listening, because I think the US, the EU, the China are big actors, but what about the others? And how the interests of the others are protected and safeguarded if we are going to go towards this bilateralism for settling disputes? Thanks.
Thank you. So I'll go back to Stephen. I haven't heard much to my question as to why governments don't use the non-adjudication means. But Stephen, Joel Trackman just sent a compliment to Olga's question. Are you saying that Stephen, that the US should not accept to be subject to any international law commitment or dispute settlement, binding dispute settlement? Is it your overall sort of a conclusion, or did we misunderstand? Well, and then after,
yeah, I guess I don't really. I mean, let's sort of talk about what it means by a binding law commitment. So, to me, when something is binding, it means that I can get a judge, or I can get a policeman or the sheriff, or somebody shows up and enforces that and makes the defendant do what they're supposed to do, right? I mean, that's when we talk about the rule of law. Okay, I entered into a contract, I didn't fulfill the contract, I get sued, I owe $1 million, I refuse to pay. At some point, the sheriff is going to step in, the courts are going to step in, they're going to make me pay, right? To me, that's binding dispute. I don't think you're going to see a situation where the United States is going to put itself in a situation where other countries can just show up and order the United States to do things that it doesn't want to do. We've never agreed to that in any context, and we didn't agree to it when we joined the WTO. If you go back and you look at the debate over the WTO in America in 1994 and 1995, the congressional record is full of comment after comment after comment from members saying, we've retained our sovereignty, it's not automatically binding on us. If you go to the Court of International Trade, both the Court of International Trade and the Federal Circuit have said over and over and over, the WTO rulings are not automatically imposed in the United States. It's up to the executive branch to go through the Section 129 process and decide, whether or not we're going to comply. So now, the idea, I think, that people are going to sort of get an order from an international body and use that order to force the U.S. government to do things that it doesn't want to do, I think it's really giving people false hope. I don't think that's ever going to happen, and I think if people think it's going to happen, they're going to be disappointed.
But what I was interested, Stephen, so in describing it, I think you're absolutely accurate. But you seem to suggest, and I don't want to put you on the spot, well, I do, but you will.
I'm happy to be put on the spot.
You seem to suggest that you think that's correct. Not correct as a prediction of how the Americans will behave. It's very difficult to reconcile. I will agree to be subject to the International Court of Justice, to the WTO appellate body, etc. But when there's a decision that goes against me, I should feel free not to comply with it.
You've made a political judgment, right? In other words, you were the president. You would go to the American people and you would say, I'm the president of the United States, acting under my authority as president of the United States. I'm going to do X, Y, and Z in accordance with this international order because I think that's in the best interest of the United States. I think it would be better for the United States to do what it's told under international law and be better for you and better for us as Americans. That's your political choice. I'm not expressing an opinion on that. My point is that I think people need to understand very seriously the difference between the America that they might like to have and the America that they actually have. And that I think y'all are being very, very unfair, I think. I don't want to use that term. I want to back up. I think the American policymakers who agreed to the GATT, the American policymakers who agreed to the WTO agreements, they were very, very committed internationalists. They were fighting very hard against things like isolationism here in the United States. They wanted the U.S. to be open. They wanted a lot of the goals that y'all are talking about here. But they understood politically that compromises have to be made. And I think the answer is not to say, well, to heck with those compromises. We're just going to try to steamroll the Americans and force them to do what we want. I think the answer is to understand the difficulties of getting the type of outcomes that you want and to work within this process in ways that are going to be productive. I think personally that the rest of the world got a lot more cooperation and a lot more support from the U.S. during the period from the 40s to the 90s than it's likely to do as a result of WTO dispute settlement. I actually think that WTO dispute settlement has led to Americans being more skeptical of international bodies, has led to Americans being more skeptical of trade deals. Between 46 and 95, we were signing new WTO agreements, new GATT agreements every few years. We haven't done one since 1994. Between the 40s and the 90s, the Americans agreed to all kind of trade deals and trade negotiations all over the place. Since the 90s, it's been very, very, very difficult. So I don't think this has had, I understand your goals, and I understand what you're trying to get to, and my advice to you is to work with the country that you have as opposed to wishing you had a different country.
And would you accept that all countries do the same as what you suggest the U.S. should do?
Well, I can certainly tell you, I don't think anybody who's a GC of USTR, I don't think anybody who's ever sat in that chair believes, for example, that we can go to Canada and say, Canada, you got to stop subsidizing your lumber people because that's a violation of various international commitments. When you sit in that chair at USTR, you understand that other countries are very, very aggressive at defending their sovereignty and defending their political interests, and I think they should be. That never bothered me. I think that's totally appropriate. I think this idea that the U.S., is going around sort of
It's
running
different.
over all
You
these
think
little
all countries, you believe that all countries essentially do what you describe the US is doing.
I think
Do I understand correctly?
yes.
Yeah.
I think some countries may feel like it's more in their national interest to promote binding dispute settlement. I think other countries may think it's less in their interest to promote binding dispute settlement. But I think everybody is pursuing their interest, which is what they should do. The Prime Minister of Canada should look out for Canada. The leaders of the EU should look out for the EU. The leaders of Brazil should look out for Brazil. Of course, that's what they should do. Their duty is to their own citizens.
So you would not be surprised if China does not comply, because you would essentially say, well, they do a bit what the US should have done more often or should do.
I don't. It has never surprised me that other countries don't comply with their WTO obligations.
We have a last 10, 15 minutes. I don't know. I mean, I'm fascinated by your comments. I still haven't got any answer as to why governments don't use the non-educated.
I'm happy to answer that question. And
yes, please. And then we'll go around.
If I were GC of USTR and you asked me, should we use good offices? Should we use mediation? Should we use these other contexts? I would advise no. And the reason I would advise no is because I believe we could be more productive and get there more quickly by just having USTR negotiate directly with the other country rather than bringing in the WTO. That's my answer.
Mm-hmm.
Thank
and
you.
You would be right, because you and I have the privilege to be citizens of the most powerful state in the world.
Well, and if I were sitting in a different chair, but even if I were sitting in a different chair, if I were representing a small nation, and somebody asked me, would we be better off taking the WTO, taking the U.S. to the WTO, and using the WTO mediation process? My advice would be either negotiate with the U.S. yourself or sue the U.S. That would be my advice, because if you negotiate with the U.S. yourself, you can leverage your foreign policy interests and other interests. If you want to sue them, you'll probably win, so you could sue them. But that would be my advice. My
advice would be slightly different. Negotiate with the United States, and if the outcome of the negotiations you don't feel that it's fair to you, then sue them.
No, I think that's exactly right. That's the advice I would give, and I think that's what most countries do.
Yeah. I also want to remind you, Gabrielle, as of course everybody knows, that in the panel procedures there's a period of consultation, but that's where our friends the lawyers come in, because they just forget the consultation. They want to bite into the living flesh and win a case.
That is what lawyers do.
You're correct. But in reality, when a government initiates consultations, very often, I suppose, they've been trying to settle before the adjudication itself. Now, what about you, Yang? Do you want to add something?
I'm very interested in the debate between two Americans on the
I don't really think it's that much of a debate. I think we actually agree on a lot of things. I think that we certainly agree that the lawyers can take this process further than it would make sense politically. I think we totally agree on that. I think we agree that in a lot of ways this WTO dispute settlement process has not worked out the way U.S. policymakers work. I think, and I certainly understand Joseph's view, which is he thinks the U.S. has certain moral obligations in terms of how it deals with other countries.
Not only moral, also self-interest ones, both.
Exactly, both. And look,
the difference between
could I ask a question? What is the importance of the principle of non-discrimination for you as lawyers in the international trade?
And allow me to.
Is it a principle that should not be looked at?
And I'm jumping in immediately because time is running, and I saw a good comment from Deborah Steger. She argues on this chat that the solution under GATT and even WTO was to withdraw the legal measure. So this is in response to Joseph's comment about compensation and damage. So the refuser were not interested in this liquidation of the effects or the damage, but hoping to simply remove the measure. So let's go around for a last round for our last 10 minutes of this amazing debate.
Well, I want to say,
oh, no, Stephen.
Can I answer the question about non-discrimination? I think it's a very important principle as a general matter. On the other hand, I do think it's a principle that's going to start to come under a lot of pressure. You know, it's very difficult for any American policymaker to come up with a solution. In other words, if you ask me, okay, let's do a deal with Canada, let's work out something with Canada. Let's do a deal with Chile, let's work out something with Chile. Let's do a deal with Switzerland, let's work out something with Switzerland. It's very difficult those type of deals are not that difficult to make. But if you then understand, okay, whatever you give to Canada or whatever you give to Chile or whatever you give to Switzerland, you're also going to give to Vietnam and you're also going to give to India, that gets much more difficult. So I think you're going to see that if we are adamant about the non-discriminatory principle, I think you're going to see exactly the sort of blockage that you've seen in the WTO for the last 20 years, because it's very, very difficult to make those type of deals these days. On the other hand, I think if you let the political people talk to each other and let things work out, you know, my guess is that the problems won't be as severe as some people think, because I think, let's not forget, the U.S. continues to run massive trade deficits. The U.S. continues to have an extraordinarily open economy. The U.S. continues to be very committed to, you know, a lot of the values and economic systems that people in this chat have been very committed to. I don't think the U.S. is planning to walk away and pull up a drawbridge and hive itself off from the rest of the world. But I think that you'll get the outcomes that you like more efficiently if you let them work through the political process.
Young, you said you had nothing to add, unless you want. Joseph,
I think a state,
last 10 minutes.
I think a state, when really push comes to shove, can violate the principle of violate its international legal obligation, but it will incur state responsibility and it will have to make some form of redress to that. But as the general, the non-exceptional situation, I think if everybody followed American practice, we could not seriously speak about the rule of law in international economic relations.
Laurence, do you want to have a last comment?
I don't think it's the last comment between these two, because I just like changing. But it would be nice to have Yang to give us his perspective about non-discrimination. But for me, when I think about the WTO, there is much more than dispute settlement. Dispute settlement obviously is one of the core functions of WTO, but there is negotiation, and there is trade reviews. And currently we have a new director general who has an agenda with new topics. And I think climate change is going to become one of the big issues, the vaccine, and so on. So I would like to just give some, optimism and show that WTO as a forum has a legitimacy and we should just preserve it. Thanks.
Well, thank you very much. And I was going to say 2 words at the end. And Laurence, you've mentioned it. The WTO is much more than dispute settlement. And the work in committees, the sort of governance work is fundamental, where countries report their difficulties and try to find solution. And we should not forget that dimension. Maybe it's a positive aspect of what is happening now. But yes, much more discussions are needed. And hopefully the miracle of the appellate body will come back in a way or another. But for the moment, negotiations is the core of the work of the WTO, especially with the new DG. So I will say personally goodbye to you, remind you that the president of SIEL, Peter van den Bosch, will say a few words right after this panel, so stay with us. But thank you to Stephen, Laurence, Yang, Joseph. It was really fascinating. I have to admit, and I'll finish with this, that when I started preparing my few intro words. I wasn't too sure where the rule of law takes us really on substance, process, procedure, and whether it's the same individual entities and governments. And at the end of this discussion that has been fascinating, I feel intellectually still, I don't want to say limited, but I have more questions than answers. But thank you for your contribution to all.
Thank you very much. It's an honor to be here.
Thank you.
You did a great job.
Thank
We
you.
really appreciate it.
Thank you very much.
Thank you for coming. Thank you.